Mr. Plymouth.
My Lords, my Lady, just before the break I was raising the question of why in a civil context like this you would be even considering introducing concepts of dishonesty under the criminal law, our submission being that you wouldn't. And I was going to go to some authority about that, just two cases. One is twin cetera, and that in the B bundle it's E588, which is B322, that being part of the judgment of Lord Millett. And your Lordship's familiar with this. Paragraph 126, he refers to the Royal Brunei case and then talks about the two different types of dishonesty in civil and criminal law. And then 127, I would resolve it by adopting the objective approach. I would do so because, one, consciousness of wrongdoing is an aspect of mens rea and an appropriate condition of criminal liability. It's not an appropriate condition of civil liability. This generally results from negligent or intentional conduct. For the purposes of civil liability, it should not be necessary that the defendant realise that his conduct was dishonest. It should be sufficient that it constituted intentional wrongdoing. And I adopt that as part of my submissions. And then the other case is in the other bundle, the supplementary bundle, it's Starglade.
Well, hang on a moment.
Yes,
do you want to deal with what is said against you, which is based on 116, 2 pages back, which is, yes, that's fine, 127 is absolutely right. It's different if what is involved is an intention to defraud. And in effect, says Mr. Spearman, that's what cheating involves.
Well, that's the circularity in the argument.
Right.
If it is indeed what it involves, then that might be a point. But if cheating is not an intent to defraud, this doesn't make it intent to defraud.
Can you cheat accidentally?
You can cheat intentionally without being dishonest in a gauche sense.
Let's do it in 2 stages. Can you cheat accidentally?
Not that I can think of.
No. But you can cheat intentionally without infringing both the 2 limbs in gauche, you say?
That's right.
I've got it.
And that is really the point in paragraph 127 of Lord Millett. He is saying that for the purpose of civil liability, it's not necessary that the defendant realise that his conduct was dishonest. It should be sufficient that it constituted intentional wrongdoing. So intentional wrongdoing is a form of reprehensible conduct which has civil consequences. You don't need to go that extra mile and say, should the defendant be sent to prison or receive some other kind of public sanction for what he's done, when, for example, he might have some mitigating circumstance subjectively that would tend to make public sanction unjustifiable.
Thank you.
And so that's the twin cetera case. The other case is the Starglade case, which is in bundle C, C78 it starts. And Sir Andrew Morritt gives the lead judgment, which I'd like to pick up at C85. And on the left-hand column, his lordship deals with the Royal Brunei case, and then he is taking extracts from the judgment of Lord Hutton in twin cetera. This is at paragraph 27, and there's an extract there. And then at 28, his lordship says, there is no suggestion in any of the speeches in twin cetera that the standard of dishonesty is flexible or determined by anyone other than the court on an objective basis, having regard to the ingredients of the combined test explained by Lord Hutton. And then he goes to Barlow-Clowes and shows how Lord Hoffman had ironed out a perceived difficulty in the way in which their lordships had expressed themselves in twin cetera. And halfway down the second column on that page, the citation is, it's just just before 16, the reference to what he knows would offend normally accepted standards of honest conduct meant only that his knowledge of the transaction had to be such as to render his participation contrary to normally acceptable standards of honest conduct, and so on. And then what Sir Andrew Morritt says on the next page, the top of the next page, is this: there is no suggestion in this case either, that's the Barlow-Clowes case, that the standard of dishonesty is flexible or determined by anyone other than by the court on an objective basis, having regard to the ingredients of the combined test as explained by Lord Hutton in Twin Sectra and Lord Hoffman in Barlow-Clowes. And then there's some further cases referred to. And then what his lordship does is deal with what the judge had said. It's paragraph 31, about halfway down. The judge said that the appropriate standard is what all, as opposed to some only, normal people would regard as dishonest is wrong in law. He contends it's not supported by any of the cases to which I've referred and is contrary to principle. For my part, I consider that the Deputy Judge's comments are apt to mislead. The relevant standard described variously in the statements I've quoted is the ordinary standard of honest behaviour, just as the subjective understanding of the person concerned as to whether his conduct is dishonest is irrelevant, so also is it irrelevant that there may be a body of opinion which regards the ordinary standard of honest behaviour as being set too high. Ultimately, in civil proceedings, it is for the court to determine what that standard is and to apply it to the facts of the case. So, although that was a case dealing with the test of dishonesty as opposed to the test of cheating, which is the issue in this case, nevertheless, the approach of a court in civil proceedings is made clear by Sir Andrew Morritt in this case. And what he's saying is it's an objective standard. It's for the court to determine what the standard is and to apply it to the facts of the case. Now, when we consider what's at stake in these proceedings, those comments are apposite, because this case is about whether or not a casino has to pay out £7.7 million to a punter under a contract. And it would be, I would submit, faintly absurd to say that this depends in part upon what the punter subjectively thought about his own conduct. If that were the test, it would mean that the casino was liable to pay out only if the punter had some subjective justification for his conduct. To put it at its lowest, it's not obvious why a contract should be enforceable or unenforceable entirely according to the subjective understanding of one of the parties as to his position. That rather cuts across the objective standards applicable to the construction of contracts and to the performance of contracts, and, as we've seen, issues arising in that similar connection, such as dishonesty. So we say it's an objective standard, as emphasised by Starglade, and we say that all that the court is required to do is to consider whether or not cheating has taken place. Whilst distinguishing between the criminal and the civil, there is also a small point here, which is to observe what is said in section 42.2, which one can find at E646 or B380. (42.2) is dealing with an aspect of the offence of cheating, and what it says is, for the purpose of subsection 1, that is, whether he's cheated at gambling or done anything for the purpose of enabling or assisting another person to cheat at gambling, it is immaterial whether a person who cheats improves his chances of winning anything or wins anything.
Yeah.
Now, that's the criminal position. But of course, in civil liability, in a case like this, money is everything. Whether he improved his chances and whether he actually won something is exactly what you are considering in considering the issues raised by whether or not he's cheated.
Well, is that right, or is it simply that it doesn't arise unless he's been successful?
Well, of course, it would. If he's been successful, then that is the reason why you would be in court arguing about it.
42.2 is there, is it perhaps for, as it were, an attempt to improve your chances?
Yes.
Or to win?
Yes.
Is it not?
Exactly. But we wouldn't be concerned with that in a civil context. The only thing that would be material to us in the civil context would be whether or not the money was made, and if so, how it was made.
Yeah.
Whereas that is a consideration which is left out of account altogether when one is considering criminal liability. So we say there's no ground for importing the concept of criminal dishonesty as a standard by which to measure whether or not the money is payable under this contract. And that leads us on then to, well, what is the court to do? And we say that the court simply adopts the course of applying the implied term, which is not to cheat or otherwise act to defeat the essential premise of the game, and see whether or not that implied term has been breached on the facts. That is exactly, we say, what the judge did. He came to conclusions on the evidence, which on the evidence cannot really be challenged, and he reached the right result. There's one other point here, which is that one doesn't need to look at whether or not, strictly speaking, dishonesty has been shown in the process of cheating, because what we can see is intentional strategy being adopted by the punter. So if the court is of the view that fixing the odds in favour of yourself as the punter by using this strategy is reprehensible conduct if accompanied by a suitable intention, then the intention here is plainly demonstrated by Mr. Ivey's own evidence, which is that is what he went to this casino to achieve, and that is what he did while he was there. And you put the intention together with the conduct, and frankly, why would that not be dishonest? Or what's the difference between civil dishonesty and intentional wrongdoing of that kind? We don't make a point that civil dishonesty needs to be proved as a freestanding matter in these proceedings. We just say, look, he cheated. He intentionally went in to subvert the game. That's a cheat. Now, you can stand back and say that's dishonest. Fine, but I'm not setting out to prove that that's dishonest in a civil sense. It probably is, and I can't see a reason why intentional wrongdoing should be considered different from civil dishonesty.
Your case is almost saying he cheated and incidentally, therefore, he was dishonest,
yes,
rather than saying, I have to consider whether he was dishonest before
That's
I consider whether he cheated.
Precisely.
You're not, or are you, contending for a concept of honest cheating?
I don't need
Except conceivably, I suppose, if you need the entirely subjective second limb of gosh.
Yes, precisely. That's where it comes in. I mean, the question of honesty is a moral label. If you take a particular moral stance in relation to intentional subversion of the game, you might then say, well, that's, as far as I'm concerned, that is dishonest. Or somebody else who hates casinos might say, well, as far as I'm concerned, that's not dishonest. But that's got nothing to do with the legal realities here, which is all that you need to prove is the intentional setting out to subvert the game.
Well, is that the second part of the implied term? Because we've concentrated on the first part of the implied term, which is to cheat.
Yes.
But the case hasn't been, the emphasis hasn't been on the second part.
Well, I did draw attention to it when going through the implied term, precisely to
But
emphasise.
why? Because the second part of it is, that can't connote dishonesty, can it? It's very difficult to see how you read dishonesty into the second part of the implied term.
Well, that would be so, yes. But one might stand back and say, well, I see that I've proved a successful attempt to subvert the game, contrary to an implied term. I would say that is dishonest. One might make that judgment. It's just, it doesn't really matter for the purpose of establishing that the casino is not liable to pay the money that's sought.
But you intentionally said about subverting a purpose without being dishonest, weren't you?
I'd have to think about that, my lord. I'm not sure that I can
Or are you
think
conceding?
of... I can't see... In this case, I'm sorry, my head is full of this case. So, and in this case, what happened was he wanted to make money at the casino's expense. He wanted to subvert the odds so that they were in his favour. And he did so employing this strategy. On the facts of this case, that intentional activity, why would that not be dishonest? I can't think of a reason.
Forgetting the facts of the case, because one's looking at construing an implied term, it does seem odd that the words that are agreed to be part of the implied term, the second part of it, is said to connote dishonesty.
Yes. Well, that, if anything, that is therefore a point in my favour. That
Well, yeah.
that is all the judge is doing.
I wasn't necessarily making a point. I was just trying to work out, because so much of the argument has been on the word
cheat. Yes,
and
indeed.
not the rest of the clause.
Yes.
Because that second part of the implied term, it seems it isn't easy to see that that part is consistent with necessarily having to establish dishonesty. That's all.
Yes. And we've pleaded it in that way just to emphasise that this is an objective question of fact.
Okay.
So has this... cheating brings in these concepts of, well, is it contrary to expectation, as it were, and is it possibly, as my friend would have it, is dishonesty part of the mix? So it's got a history, it's got a content.
Okay.
Setting it out more concretely, which is that you certainly don't go intentionally to subvert the game, that is what we're dealing with here. So it remains, whilst drawing these distinctions, just to consider briefly the different judgments in the Court of Appeal. Lord Justice Tomlinson dealt with the matter pretty much as had the judge, but drawing a few more inferences to the advantage of the casino. Lady Justice Arden took a different approach because she considered the position as it being the equivalent, or maybe the fact, of an implied term not to commit the criminal offence. But the important point I just wanted to draw to your Lordship's attention is that, of course, Lady Justice Arden, when saying that, had already decided, as she says so in her judgment, that dishonesty, that is, criminal dishonesty, was not part of Section 42. So you can see in Lady Justice Arden's mind, she's faced with an implied term which says not to cheat or subvert the game, and a separate responsibility not to commit a criminal offence, namely to cheat at gambling. And she's wondering, well, what's the difference? And so on her analysis, she says, well, it's no more and no less than the implied term not to commit the offence. Now that's not true, though, when one gets to Lady Justice Sharp's analysis. She adopts Lady Justice Arden's approach to the extent that the implied term should be the implied term not to commit the criminal offence. But in Lady Justice Sharp's case, knowing that she's going to find that dishonesty is part of the mix. So what in our submission has gone wrong with Lady Justice Sharp's analysis is that she hasn't considered what Lady Justice Arden would have thought to be the position if she'd agreed that dishonesty is part of the mix. It's not at all clear from Lady Justice Arden's judgment that if she thought that dishonesty was part of Section 42, that she would have said the implied term was the same. So from our submission, we say that this was an unsatisfactory outcome, that Lady Justice Sharp really didn't consider the position in the right way. Lady Justice Arden was able to conflate the two because there was no dishonesty requirement. But Lady Justice Sharp couldn't do that because there was a dishonesty requirement in her mind, but then didn't go on to consider whether there was a separate implied term which does not require criminal dishonesty.
Mr. Pymont, this morning I put the analogy of someone playing bridge and getting their partner or opponent to move so they could see their cards in the mirror. It might be said that actually, as we were discussing this case over the adjournment, pointed out that maybe it'd be cheating even if you didn't ask the person to move. If the person, if your partner or opponent was in front of a mirror and you could see their cards.
That is cheating. You're not supposed to see cards. In fact, I think the judge quoted from an old edition of Smith and Hogan, which is that looking at someone's cards is cheating. In general parlance, not in a casino sense, but in the kitchen bridge sense, if somebody just peered over your shoulder or looked in the television screen to see the reflection of your cards, that is considered cheating. You're not supposed to have that information under the rules of the game.
Isn't that, in a way, proving too much? Because, or does it cast doubt on your concession that if I happen to notice as a punter in the casino that the cards haven't been shuffled? What's the difference between that in the casino context and what we were just talking about in the bridge game?
Simply that it's the casino playing that is dealing the game. It's
Right.
all of that is in the casino's hands.
Yes.
Where you have a game against one another, you have a slightly different dynamic. This is not baccarat because it's not a game against one another. Where you are playing against one another, the rule, the convention, is that you do not look at one another's cards. And the information that you get in bridge is whatever you find from the bidding process. But otherwise, you don't know anything about the lay of the cards, and you're not supposed to.
So the difference is that the players are all on an equal basis, whereas in a casino, your relationship with a punter in the casino is slightly different.
It's slightly different. The
Yeah,
casino...
but then the whole bridge analogy falls apart, doesn't it? Because the question is, at what point
Yes.
can the divergence occur? So maybe it wasn't a very helpful analogy.
All these analogies are to a greater or lesser extent helpful, and some more than others.
It's a fair point about
The
analogies.
important point to note, though, which is where it is a helpful analogy, is that the game is that you play against one another without looking at one another's cards, and you're not supposed to have that information. That is the analogy that I would draw from your Lordship's example.
Well, you could say then you're not meant to know this is likely to be a 7, 8 or 9, and yet if you've worked out without influencing the game that it's a 7, 8 or 9, you're inclined to say that's not because you haven't done something.
We're inclined to say we made the mistake.
Yes. In this sense, you made the mistake because they asked you to do something and you should have said no.
Well, that's not a mistake, though. That's an induced action.
What was the inducement?
They asked us to do it, knowing
What's
that
the
we want to do whatever you want. The casino is a branch of the entertainment industry.
So just coming back to that, the possible misleading isn't really relevant then. The mere fact of asking you to do it's enough.
We would say so.
Yes, I think.
It was also clothed in to throw us off the scent. All the background superstition and so forth is to make us throw us off the scent. So that if he just boldly were to state, "Can you turn the cards this way or that way?" whenever I say, somebody might say, "What's the reason for that?" But all this, "Give me my lucky hat. Can I use the lucky card?"
But I'm sorry, but I'm just trying to examine it a bit more analytically. If he just said, "Please do that," and they'd done it, what then?
If we had
No
not
funny hats.
If we had not known what the purpose of it was, then he would be interfering in the game.
So essentially your primary case, I appreciate you don't have to put it only one way, but your primary case is asking you to do it is enough.
Yes.
He's altered, yes, all right.
Asking that we do it, knowing that we don't know what
Yes.
he's doing it for.
Because if you did know, of course, there's the possibility of you doing it.
Exactly.
Yeah.
But that's the interference with the game. And
Making
that's,
you his unwitting agent,
yes,
as it were. Not necessarily legally, but in effect.
right.
Okay.
So, putting that together, we say that the judge was right on the implied term. We did succeed. We should continue to succeed. Section 42, therefore, has nothing to do with it. The judge has come to a conclusion which has not been challenged. The only challenge that's been put forward in this court is Section 42, and so I shall now go and deal with that. But we say that is a freestanding argument
Yeah.
which has its own...
That's the third point. Not the second point is the one you've been dealing with, the implied term, which has nothing to do with Section 42.
That's right.
But the third option, alternatively, if you fail on the second, is the Section 42.
Is the Section 42. So, as your Lordship has indicated, this was, of course, a point that was raised by the defendant, not by the claimant originally. This was the defendant's alternative argument that it was not liable to pay the money because a breach of Section 42 had been committed, and that would mean that Mr. Ivey was effectively suing for the proceeds of a crime, or alternatively that there were illegality in performance of the contract which would vitiate his right to recovery. So that was the submission that was going to be made. And Mr. Ivey has adopted the different treatment analyses that have taken place in the Court of Appeal to be able to bring his point to this court, even though it was never part of his original case, that, and there's nothing on the pleading about it, that criminal dishonesty is part of Section 42 and that he was subjectively not dishonest. To that extent, it's...
Well, it was certainly part of his case that he was subjectively not dishonest.
Yeah, I mean pleaded case. It became part of the
Oh,
argument before the judge as the argument developed. But in this court, this is something of we would say, something of an opportunistic or adventitious plea. But be that as it may, I have to deal with it. So I now go on to deal with Section 42, if I may. Our submission is that dishonesty in the criminal sense is not a requirement of Section 42. We also say separately that even if it is, there are sufficient facts for this court, if necessary, to draw the appropriate inferences as to the required state of mind, and that on that basis, Mr. Ivey was dishonest in the criminal sense. So dealing with the first point first, the meaning of Section 42, first port of call is to look at the section which is in E646. And the section is organised as stating the offence first at 1, and then the point that I took your Lordship and your Ladyship to earlier about being immaterial, that he improves his chances of winning anything. And then 3 are some particular activities which are to comprise the offence of cheating at gambling. And then there's the sanction for that with some other sections which include at 6, Section 17 of the Gaming Act shall cease to have effect, and we'll come back to Section 17 in due course. Now you look at that section and very clearly there is no reference to dishonesty anywhere. Though it is a modern statute, and I would suggest one would expect to see a requirement of dishonesty where that had been specifically intended. So Mr. Ivey's case is essentially that there is some way of implying a freestanding dishonesty requirement. Now,
Well, his case, I think, is criminal statutes are generally to be construed to require mens rea, and that in this kind of case, the appropriate mens rea is dishonesty.
well, that's
That's how it's done, I think.
That's exactly where I was going, which is to say this: the appropriate course for a court to take when looking at a statute like this, which does not in terms say anything about the mens rea, is to investigate what the mens rea may be. Yeah. And I'm going to go on to do that, but just to foreshadow what's coming, my submission is that one could conclude, in fact one should conclude, that the relevant mens rea is intention and not dishonesty. Dishonesty is an extra requirement which is not warranted by anything in the background to the Act, any analogies, the language used, the concept of cheating, or anything else that my friend has put forward. So, looking at mens rea, there are various ways to try and work out what that is. The leading case is Sweet and Parsley,
Yes.
which I must go to. This is at E517.
Thank you.
And to remind your lordships and your ladyship that this was a case where...
I think we know the fact.
You know all about this, very good.
It's knowingly, isn't it?
No, exactly. This is
Knowingly, yes.
smoking cannabis, and whether you've been concerned in the management of a premises where cannabis has been smoked.
And there was no requirement, express requirement of knowingly or suspecting or anything like that in the Act. No.
So the House of Lords had no difficulty in rejecting the submission that the offence was effectively one of absolute or strict liability. So that was a given, as it were. But then, just going under the surface, what's interesting is how they then tried to work out what the mens rea actually was, because they take slightly different approach, and it's not, they don't speak with one voice. Lord Reid at E535 from letter B,
Right.
that's B269.
Yeah.
He says the choice would be much more difficult if there were no other way other than either mens rea in the full sense or an absolute offence, for there are many kinds of case where putting on the prosecutor the full burden of proving mens rea creates great difficulties and may lead to many unjust acquittals. But there are at least two other possibilities. Parliament has not infrequently transferred the onus as regards mens rea to the accused, so that once the necessary facts are proved, he must convince the jury that on balance of probabilities he is innocent of any criminal intent. I find it a bit surprising that more use has not been made of this method, but one of the bad effects of the decision of the House in Wilmington may have been to discourage its use. The other method would be, in effect, to substitute in appropriate classes of cases gross negligence for mens rea in the full sense as the mental element necessary to constitute the crime. It would often be much easier to infer that Parliament must have meant that gross negligence should be the necessary mental element than to infer that Parliament intended to create an absolute offence. A variant of this would be to accept the view of Miss Justice Cave in Tolson. This appears to have been done in Australia, where Miss Justice Dixon in Proudman and Damon says, as a general rule, an honest and reasonable belief in a state of facts which, if they existed, would make the defendant's act innocent, affords an excuse for doing what would otherwise be an offence. It may be that none of these methods is wholly satisfactory, but at least the public scandal of convicting on a serious charge persons who are in no way blameworthy would be avoided. And then, looking at the different approaches, Lord Reid himself, over the page 151 of the report, just after D, he refers to equivalent language in an older act, the Dangerous Drugs Act 1920, and then effectively applies the meaning that is clear from that act to the same form of words in the act with which he's dealing. Lord Morris, who's the next judge to deal with the matter, he takes a slightly different approach, which one can see at page 156 of the report.
Yeah.
And he finds it from the language of the section itself, at the top of the page, A. For the reasons I've indicated, I consider not a fair reading of the phrase, concerned in the management of premises used for the purpose of, a link is denoted between management and user for a purpose. To say that someone is concerned in the management of premises used for the purpose of smoking cannabis involves, in my view, that his management is with knowledge that the premises are so used. And so that's the mens rea. Then Lord Pearce says that the Tolson approach is possible. That's at 158 of the report at B, where he refers to the judgment of Mr. Justice Cave and an article from Australia where this approach had been taken up. But he says just after E, but it's not necessary for the purpose of the present case to go fully into that aspect of the matter. And then what he does is rely upon the history again, which is, one can see after G, he's looking at the meaning of the same phrase in an earlier act. Then there's Lord Wilberforce, and...
So Lord Pearce really takes the same view as Lord Reid? As
Lord Reid, yes. And Lord Wilberforce takes the same view as well, and that's at 160 just before C, where he starts a consideration of previous analogous legislation removes any doubt.
Thank you.
And then finally, Lord Diplock. Lord Diplock takes up the Tolson approach, and that's at 162 just after B, a more helpful exposition of the nature of mens rea in both common law and statutory offences is to be found in the justice of Mr. Justice Stephen in Tolson. He said, the full definition of every crime contains expressly or by implication a proposition as to a state of mind. Therefore, if the mental element of any conduct alleged to be a crime is proved to have been absent in any given case, the crime so defined is not committed, or again, if a crime, if fully defined, nothing amounts to that crime which does not satisfy that definition. Where the crime consists of doing an act which is prohibited by statute, the proposition as to the state of mind of the doer, which is contained in the full definition of the crime, must be ascertained from the words and subject matter of the statute. The proposition, as Mr. Justice Stephen pointed out, may be stated explicitly by words such as maliciously, fraudulently, negligently, knowingly, and so on, which may require judicial exegesis. And even without such adverbs, the words descriptive of the prohibited act may themselves connote the presence of a particular mental element. Thus, where the prohibited act consists in permitting a particular thing to be done, the word permit connotes at least knowledge or reasonable grounds for suspicion on the part of the permitter that the thing will be done, and an unwillingness to use means available to him to prevent it. And to take a recent example, to have in one's possession a prohibited substance connotes some degree of awareness of that which was within the possession's physical control. But only too frequently, the actual words used by Parliament to define the prohibited conduct are in themselves descriptive only of the physical act and bear no connotation. And then he goes on, you still have to find some implication. Then he refers to Macnaghten, insanity, and then over the page, duress. And then just after A, 3 lines down from the top of the page, but the importance of the actual decision of the 9 judges who constituted the majority in Tolson, which concerned a charge of bigamy under section 57 of the Offence Against Person Act, was that it laid down as a general principle of construction of any enactment which creates a criminal offence, that even where the words used to describe the prohibited conduct would not in any other context connote the necessity for any particular mental element, they are nevertheless to be read as subject to the implication that a necessary element in the offence is the absence of a belief held honestly and upon reasonable grounds in the existence of facts which, if true, would make the act innocent. As was said by the Privy Council in Bank of New South Wales, the absence of mens rea really consists in such a belief by the accused. And that's what's important for a rational, civilised criminal code, and so on. So that's a slightly different approach, which is to avoid otherwise innocent conduct being caught up and penalised, where there is a belief, honestly and upon reasonable grounds, held in the existence of facts which, if true, would make the act innocent. So that's another way of stating whether or not the offence should be committed. Now, those are various possibilities then. The first point we have to address is to see what we can say as a matter of construction of the section, including what might be implicit in the section in the way that's foreshadowed by Lord Diplow. If there's anything that we had. Then, as other of their lordships took the approach, that we can consider matters of history and analogy, so similar forms of words in similar statutes. And then there's always the Tolson approach, which is to see whether it's really up to the defendant to say, well, I wasn't guilty of this offence because I had an honest belief based on reasonable grounds. So construction, perhaps the only helpful, potentially helpful words is in subsection 3 of the section, which is it's a section which sets out certain specific activities which may consist of which the offence may consist. This is page E646.
Yep.
And so those are, cheating at gambling may in particular consist of actual or attempted deception or interference in connection with the process by which gambling is conducted or a real or virtual game. Now, my submission is that it's implicit in that formula that this is not to be interference, unknowing interference, or inadvertent interference, or accidental interference. This is intentional interference in the game, because that's inherent in the concept of interference. Likewise, deception, it's a bit difficult to understand whether you could have accidental deception. As my Lord Hughes putting to me earlier, accidental activities of this kind are not caught by the section. It's rather meaningless to talk about accidental deception. So what it must be driving at is some kind of intentional activity. Now, if that is as far as one needs to go, this is an intentional activity, then one doesn't need to add on top of it some extra requirement that is to the effect that shall be dishonest. Just think of the context. The context is cheating at gambling. So this is trying to actually succeeding or trying to get an advantage from playing a game. All that's required by the Act is that you should intend to do that. Once you've intended to do that, that's sufficient wrongdoing to be penalised by the statute. Why should it matter that you had in mind that other people might think that this was perfectly acceptable conduct?
Is it enough to have intentional interference in the process, or you can test it perhaps as I think Mr. Spearman did? If you look at B, is it enough to have intentional interference in a ... race? And hence the suggested protester who throws herself in front of the racehorses. Would that be cheating?
Well, the judge himself, through that argument, as a possibility up in argument, in closing argument.
Right.
And he answered it to his own satisfaction anyway, by saying, oh, I see, this is an offence of cheating at gambling, so you've got to be playing the game if you're going to be gambling. So you can't just wander on to a race course and throw yourself under the nearest horse and say that that is an offence of cheating at gambling. You've got to be playing the game in order to be interfering with it for the purposes of the...
Unless you were doing that with a view to winning a bet.
Yes,
that you
unless...
knew about that somebody else had placed.
Exactly so.
Yes, I see.
Can I go back and ask you, if you look at cheating in the first head of your argument, you can cheat in a race simply because you don't like someone. You just, I don't want this chap to win, you trip him up. But that couldn't possibly apply when we're looking at cheating in relation to gaming, because there must be an element of getting some pecuniary, well, it reduces pecuniary advantage, but it must be definitely connected with gambling.
Yes.
Isn't that the difference between your implied term and Section 42 and the Section 42 use of the word cheating?
It could be. I think your Lordship is putting to me the words in B, this is deception or interference in connection with B, a real or virtual game, race or other event or process to which gambling relates. In other words, it has to be a gambling process. You have to be involved in the pursuit of gambling for your interference in the game to be the subject of possible offence. And yes, we entirely accept that.
Because if you take a football game, for example, and A dislikes B so much that he decides, not for anything to do with gaming, to trip someone up, but if he does it, of course, being put up to it, to enable someone to win a bet, and isn't that what's required under you have the element of deliberate interference, but it has to be connected.
Precisely. One thinks of the cricket example from a few years ago, where the betting was taking place in the Far East on how many nobles there would be in a particular over, that kind of thing. And then money was paid to one of the cricketers to produce the goods, and sure enough, bowled an over with the requisite number of nobles in it. And so that kind of activity, now that would be an interference with the game, and that would be a commission of an offence, because it's all about gambling. You are helping somebody else to cheat at gambling, essentially. So this is all about cheating at gambling, but it's not helpful, therefore, to be looking at sort of wider things such as Emily Dickinson throwing herself under the racehorse, or indeed my friend's other examples, which were somebody coming into a casino because his relative was betting too much and just smashing the place up and stopping the game. That's not cheating at gambling. That's just criminal damage. So, but it's not within the offence. So one needs to remain within the ambit of Section 42. It is an offence about what takes place at gambling. And so in that context, we say, well, it is the idea that you should be inadvertently interfering with the game when you're gambling, and you should be penalised for it. We would say, plainly not. Likewise, deception. Why would you be using deception in connection with the game? Answer, because you're doing so deliberately, intentionally. Whether or not you actually succeed is immaterial under subsection 2, but nevertheless, that's the reason why you're doing it, and that's why your conduct is penalised. What you don't need to do is ask what's going on in your mind otherwise about whether or not you think you can act in this way. That's the gauche test, and there's nothing in section 42 which suggests that that extra step is part of the mix. So we would adopt a sort of what Lord Morris did in Sweet, which was to spell out the intention just from the form of activity that is being penalised. Going beyond that, there's the dictionary meaning that my friend relies upon. Well, that rather runs into the sand because we have a battle of the dictionaries before the court. We have some which seem to refer to dishonesty, others as fairness, as being all that's in issue. But of course, it doesn't help anyway because we're not talking about dishonesty in a civil or a criminal sense. So what in fact is the difference? I go back to something I said in my submissions as the implied term. What's the essential difference between dishonesty, generally, for cheating purposes, and intentionally fixing the odds on a game of baccarat? They could easily be considered dishonest by both people. It's the same thing. So my friend's resort to the dictionary definition doesn't help him to establish that gauche dishonesty is part of the mix. So then we go to history and analogy. Let's start with history. There's nothing here to support the argument that gauche dishonesty is a requirement of the commission of the offence. There's nothing like there was in Sweet and Parsley to guide the court as to the meaning of the words of this section, because there is no forerunner to this section that's anything equivalent to its current terms. This is a new section, 2005, newly generated in the new world of legal gambling. And it was written specially for the purpose. But we have some of the history in the material before the court. Maybe it's not necessary to go through all of it, but we would flag up these points. The first is that if you go back to the early statutes, Charles II, for your note, is E649, and the Statute of Anne at E652. Those both have some rolled up descriptions of reprehensible conduct, fraud, cozenage, deceit, etc., etc. But one of them is the concept of ill practice. And that appears in both of them. Perhaps I will go to them. E649 is the first. It's not very easy to read, but under the heading Chapter 7, an act against deceitful, disorderly and excessive gaming, the second complete paragraph, marked 2, starts, be it therefore enacted, and then third line down, that if any person or persons, and then drop down 2 lines, do or shall, by any fraud, shift, cozenage, circumvention, deceit, or unlawful device, or ill practice whatsoever, in playing at or with cards, dice, tables, tennis, bowls, kittles, shovelboard, cockfightings, horse races, dog matches, and so on and so forth, drop 2 or 3 lines, win, obtain, or acquire to him or themselves, or to any other or others, any sum or sums of money, or other valuable thing or things whatsoever, then every person and person so offending as aforesaid shall ipso facto forfeit and lose treble the sum or value of money or other thing, so one gained, obtained, or acquired, the one moiety thereof to our sovereign lord the king, the other to the person or persons aggrieved. That's the essence of that. And so that is something that applies when there is ill practice, as well as fraud or cozenage or other more obviously dishonest activities. And the same in the Statute of Anne, that's on E652, looking at section 5, just over halfway down the page. Be it further enacted, if any person or persons whatsoever at any time or times after the said first day of May, etc., do or shall by any fraud or shift, cozenage, circumvention, deceit or unlawful device or ill practice whatsoever in playing at or with cards, dice, and so forth, win of any more, one or more person or persons whatsoever above the sum of £10, then every person or persons so winning by such ill practice shall be convicted, shall forfeit 5 times the value of the sum or sums, and shall be deemed infamous and suffer such further corporal punishment as in cases of willful perjury. So again, ill practice is an aspect of it, in addition to more obviously dishonest practice. And then this is a phrase which continues to form part of the statutory provision, in that Section 17 of the Gaming Act 1845, which is on the opposite page, E653, and Section 17 being the section that was repealed by Section 42, still continues, be it enacted that every person who shall by any fraud or unlawful device or ill practice in playing with cards, dice, and so forth, and so on, shall be deemed guilty of obtaining such money or thing from such person by a false pretense, with intent to cheat or defraud such person. So if you do that, you're deemed to be a fraud, not you have to prove fraud as part of the offence.
Yeah.
The gloss on that in the cases is Queen and Moore, E392, which was the old 3-card trick on the train. And the Lord Chief Justice, at the bottom of 55, this 55 of the report, I should say, about 5 lines up, says, further it said that there was not an unlawful device or an ill practice within Section 17. The substance of this issue was put by the Deputy Chairman when he said that the jury were entitled to consider the matter of the turned-up card, and if they thought that the game was fairly played or had any doubt about its unfairness, they must find for the defendant. The Governor of Brixton's case, cited by Mr. Horton, decided that the false representation must be in connection with the game itself. The jury evidently thought that turning up the end of the court card was an ill device by which the prosecutor was induced to part with his money. And we are of opinion that there was evidence before them upon which they could come to this conclusion. So he was suckered into it by being shown that there was a corner of one of the cards turned up, which rendered it certain that he would win. That's what's said at the top of 55. Was the game fairly played? That is a question for the jury. But the important point is, was it fairly played? Was there a fraud? Answer, no, because there's no particular misrepresentation necessarily in what had happened. The question was whether there was any doubt about its unfairness or whether it had been paid fairly. And so Section 17, which is the immediate forerunner in this area, albeit in completely different terms, Section 17 does not allow one to say that dishonesty was undoubtedly part of cheating in the statutory history behind Section 42. Perhaps even more briefly, I can just say that common law cases go back to a 15th century writ which deals with loaded dice and seems to have been used for things like the 3-card trick as well. Lady Justice Arden dealt with that fairly briefly, and we say correctly in paragraphs 49 and 50 of her judgment. The only thing I'd add to that is that the form of writ talks about fraudulenta and so forth as part of the cause of action, this being a writ creating an action on the case. And there is an important qualification that is given by Professor J.H. Baker in his Oxford History of English Law, Vol. 6, which is in the material before the court at E675. Turning over the page at 676, dropping about halfway down the print on the page. That second, however, we find that deceit or fraud is frequently pleaded as a constituent factual element in declarations upon the case. The usual phrase is craftily scheming to defraud the plaintiff, describing whatever the defendant is alleged to have done or failed to do. Sometimes the word defraud gives way to harm, impoverish, or cause loss, and it may be that it was used in the same morally neutral sense as indicating loss caused by misleading words or conduct rather than deliberate falsehood. Admittedly, that's not the primary meaning of fraud or deceit, but there's nothing in the contemporary sources to suggest that in many actions on the case in which the allegation was made, including the majority of assumpsit cases, there was any need to prove an intention to deceive. It was evidently expected of the pleader to use some formal exaggeration in magnifying the misconduct of a defendant, and occasionally the invective was quite imaginative. Dropping down, the footnote says, scheming to defraud the plaintiff and not fulfill his promise, and through his evil and impudent cunning to make him lose his goods and money. And another one, by pernicious and perfidious wickedness, scheming maliciously to harm the plaintiff. But it was not taken seriously, going back to the print. And it cannot have been part of the issue for the jury. This obviously makes it difficult for the historian to distinguish between the true cases of deceit in the plea rolls from the cases where words of deceit are no more than formal abuse of the defendant. Nevertheless, there were several species of action in which deceit appears to have been a material part of the plaintiff's case, and so on. So there is a check in looking at these very old common law cases and this old writ. One doesn't rush to say that just because the Latin fraudulenta appears as part of the wording of the writ, that means there's an obligation to prove dishonesty. So we get nothing out of looking at the old statutes or the old common law on cheating at gambling. We then look at analogy, and really this is what my friend is saying. He pins his case, really. He says everything you need to know is in Scott and Metropolitan Police Commissioner, because which is a case which deals with various other forms of cheating and fraud. But all the examples that are given in Scott are examples of things that are not cheating at gambling. They're all expressed as cheat and defraud, as a rolled up offence of some kind. The particular one is cheating the public by false weights and measures, which is commented upon at page 840, none of which comes anywhere close to cheating at gambling, or limiting the effect of ill practice in the gambling statutes, nor does it come anywhere close to the sort of analogy that was taken by the House of Lords, or some of the judges in the House of Lords, in the Sweet and Parsley decision, where the exact same form of words was used in the earlier Act with a clear meaning, and the court was able to read that meaning into the new Act. And then my friend says, oh, well, there's going equipped to cheat in the Theft Act, sections 15 and 25, which section 25 defines cheating as including section 15, expressly defines cheating for the purposes of section 25 as including section 15, which is an offence which includes expressly dishonesty.
Is it including or as limited to?
It's in C. It's the last document in C. 25 is on page C92. A person shall be guilty of offence if, when not at his place of abode, he has with him any article for use in the course of or in connection with any burglary, theft, or cheat. And then 5, for the purpose of this section, cheat means an offence under section 15.
Yeah, means.
Means, exactly. So specifically there, a definition has been given to refer back to, in shorthand, to section 15, And Section 15 is indeed, in terms, on page C90, an offence of dishonesty. Any person who by any deception dishonestly obtains property belonging to one another. So both deception and dishonesty. But these are express statutory definitions which, in a completely different context, which signally don't exist in Section 42. And it's therefore quite wrong to be considering that there is some implication for the meaning of Section 42 from these other uses. In my friend didn't refer to it, but my friend's argument, he also refers to the King and Sinclair, or Queen and Sinclair case, I think. And that's another conspiracy to cheat and defraud case by dishonestly taking risks with the company's asset, knowing it not to be in the best interest of the company and to be prejudicial to minority shareholders. That's at E395. But then again, that's a clear fraud defence. As against those which we say are just completely unhelpful, what we say is there are some more telling analogies which the court ought to bear in mind when considering a dishonesty requirement, where offences which might in general terms be thought to involve some kind of dishonest intent, morally dishonest, morally reprehensibly dishonest intent, in fact do not do so. We've put in our written statement at paragraph 56 and copied the relevant legislation in the B bundle, a number of different offences which may be thought to be of this kind. But can I just take two? They are the corruption cases and the forgery cases. The corruption cases start with the case of Cooper and Slade, which is E310, B44, sorry, B. Yes, 310, B44, which was a case about bribery. One can see at the bottom of B45, that's E311, the reference under the footnote to the relevant offence. The second section declares that the following person shall be guilty of bribery: every person who shall directly or indirectly by himself or any other person or on his behalf give, lend, or agree to give or lend, or shall offer, promise, or promise to procure, or to endeavour to procure any money or valuable consideration to or for any voter, or to or for any person on behalf of any voter, or to or for any other person, in order to induce any voter to vote or refrain from voting, or shall corruptly do any such act as aforesaid on account of any such voter having voted or refrained from voting at an election. So that's the offence. And Mr. Justice Wills says about this at page E321, B55, the first complete paragraph on the page. In answer to the third question, I'm of opinion there was evidence that the defendant corruptly paid money to Carter on account of his having voted at the election. I think the word corruptly in this statute means not dishonestly, but in purposely doing an act which the law forbids as tending to corrupt voters, whether it be a pecuniary inducement to vote or a reward for having voted in any particular manner. Both the giver and the receiver in such a case may be said to be acting corruptly. The word corruptly seems to be used as a designation of the act of rewarding a man for having voted in a particular way as being corrupt, rather than as part of the definition of the defence, of the offence. So just thinking about that, again, here we have a section which penalises or refers to a particular type of conduct, like interference and deception in connection with a game for the purpose of cheating at gambling. One can see that, well, okay, because you need to interfere, because you need to have acted deceptively, you need to be doing that with knowledge of what you're doing. So that's implicit in the section. But to go that one stage further and say there's also dishonesty, Well, you don't need that. It's not what the section is. All the section is doing is creating a definition for the offence which does not involve dishonesty. So Cooper and Slade, although an old case, is then referred to in, say, later cases, one at E382,
Right.
which is Harvey,
Yep.
and the principle is applied in relation to a different, a more modern corruption act. The advantage of Harvey is that from 388 onwards, you get the citation of Cooper and Slade, and then you also get other cases in the same vein, Queen and Smith, Queen and Welburn, and then the dishonesty point is raised by counsel for the defendant, and the conclusion is, 4 lines up from the bottom, dishonesty is not an element of obtaining corruptly within the meaning of section 1.1 of the 1906 Act, and so on. And there are other cases which we've referred to which then continue in the same vein. Now, just to round off that line of thought, we now have the Bribery Act, of course,
Yes.
2010, which is at E605.
Yep.
And this, again, is shaped as an offence of intention and not of dishonesty, even though its subject matter is bribery.
Yep.
So 605 gives a number, starts the relevant sections. The first one is case 1, as it's called, subsection 2. P offers, promises or gives a financial advantage or other advantage to another person, and P intends the advantage to induce a person to do this and that.
It's improperly, that's the point.
That's right. Yeah.
Okay.
And case 2 is similarly, he offers or promises, and he knows that that's an improper performance, and so on. So intentional knowledge, we see that over the page in section 2, subsection 2,
Yep.
and 7, cases 4 to 6. It doesn't matter whether he knows or believes that the performance of the function or activity improper. So there's an express requirement that he doesn't know about the impropriety. But this Act sets out very carefully what, and over the page, section 6, this Act sets out what is required. And what is required is just an intention to do that with knowledge of its consequences. It's not to do with dishonesty, and certainly not dishonesty in the gauche sense. And the only other one, as I suggested I was going to look at, was the forgery cases. 640, again, you'd expect 640 to be, forgery to be an offence of dishonesty. This is forging registers of births, baptisms, marriages, deaths, and so on. And 4 lines down, shall knowingly and unlawfully insert or cause to be inserted, and so on. Likewise, section 37, whosoever shall knowingly and willfully insert, and so on. And then the current offence of forgery over the page in the Forgery and Counterfeiting Act 1981. A person is guilty of forgery if he makes a false instrument with the intention that, and so on.
Yeah.
So that's it. It's not, you don't rush to find dishonesty as a freestanding requirement.
Sure.
So one puts all this material together, and I'm sorry, I spent some time on it, but in the end, I'm going to say that it's no help to you, or it's a very little help, insofar as you can find anything from it at all. One finds that the better course is to read intention as the appropriate mens rea. And certainly, one finds no grounds at all, I submit, for importing gauche dishonesty. I'm hurrying along. The court will know that we have some pepper and heart material, which may, if the court is still concerned about Section 42, regards it as obscure or ambiguous. That's the pepper and heart test. It is possible to go to the material that we've put in, which are the standing committees in the Commons and the Lords, in both of which the relevant minister, Mr. Richard Cabourn, explains that the test that they wanted to put in was that of unfairness, whether he unfairly gained an advantage. And there's no reference in any of it to dishonesty. Just very briefly, if I may,
Well,
E689.
We're all looking at you.
Sorry, not E689.
I certainly wouldn't encourage you to spend much time on this, Mr. Piemont.
Very good.
We've got the references in your...
You've got the references. I won't pursue in that case.
Thank you.
So that then is all I say about Section 40. I say dishonesty is not part of the mix. If it's not, then Lady Justice Arden was right, changing her implied term not to comply with Section 42 to my ground 3,
Yes,
which is
fair.
simply not to commit a criminal offence. Lady Justice Arden's treatment of that was right. There's interference, there's intentional interference on the findings of the judge.
I'm not sure where it goes, but just going back to the second point, I'm sorry about this, the implied term. We're in slightly odd territory here, because normally if there's an argument about whether somebody is in breach of an implied term, one looks to see whether the action would be one which would satisfy, or the forbidding of the action would be something which would satisfy the normal requirements of implied terms, obvious for business, or obvious, so obvious it goes without saying, or necessary for business efficacy. Here we've slightly sort of finessed that by agreeing on the implied term and then arguing about whether the particular action satisfies the implied term.
Yeah.
But in the end, isn't the issue really whether it's so obvious that it goes without saying? You have to say, in order for this to be excluded, it either is necessary for business efficacy or so obvious as to go without saying, don't
Yes.
you?
And I do say that.
No, I'm sure you do, but I mean, that is the right test, isn't it? The mere fact that you and Mr. Spearman may have agreed the test, and then it's almost as if we're treating it as an express term which has been agreed,
Yes.
and seeing if it's breached,
Yes.
which is a slightly odd way of looking at whether what you've done is breach of implied term, isn't it?
Well, we can. It's up to my friend, of course. He can,
I
he
know,
can
but
disagree
I'm
with.
raising this because
course.
in our thought processes afterwards, this may play a part, and I think it may be an unhelpful point or go nowhere, but I feel I should raise it with you and also with Mr. Spearman.
I go back to the point that I made, really in relation to this very point about obviousness, which is that if you go in off the street into a casino, then you as the punter can expect that the casino will play the game properly and won't seek to claim an advantage beyond its house edge, won't seek to stitch you up and take your money off you. And by exactly the same token, the casino is welcoming you in order to offer you the game that it is offering, and to say, yes, if you win at this game that I'm offering, I'll pay you some money.
The other possibility is one might say, well, look, the casinos are more than capable of looking after themselves, provided I don't do anything dishonest. I can do what I like to try and take advantage of the casino.
I'm sure a number of punters would think in those terms. That is certainly not how casinos think of themselves.
I know, but it's not
they are
enough that
not.
one party might think that's what the term should be.
Well, of course, we are now in a new world. In the old days, a casino was fair game because it was completely outside the law, as it were, contractually anyway, because the gaming contracts were not lawful. And so it had to be regulated another way, namely by the old Gaming Commission, now the Gambling Commission. But we're in a new world now where there are gaming contracts that can be formed. So if you go into an establishment in order to play a particular game, then you are entitled to expect the establishment will not try and stitch you up. And the establishment is entitled to expect that you will not stitch them up. It's perfectly mutual. There is nothing other than prejudice to suggest that casinos are fair game for cheating activity. That is absolutely, commercially, not the case. And we would resist any suggestion. So if one goes that far, just that it's not proved by evidence that you can just take a kick at a casino, that on the contrary, it is now a tightly regulated industry which is entitled to form contracts with its punters. If one understands that to start off with, then the implied term follows, because it becomes obvious that you'll treat each other fairly, just like any other equivalent situation. In any other equivalent situation, both parties would treat each other fairly. You are not setting out in commercial arrangement of this kind to take advantage of one another.
Or to take unfair advantage.
Unfair advantage of one another, indeed. But as I say, in Baccarat, there's no advantage to be taken. You just bet, and then you play out.
So you say in the end it may be unhelpful, but it's almost that neither party can act unfairly, although, as I think both of you, well, anyone would accept unfairly is a fairly elastic concept. Sorry, it's a reasonably elastic concept.
Yes. But in the end, it's a matter of the court.
It comes back to cheating. It comes back to the same. Okay.
And it comes back to the sort of approach that Sir Andrew Morritt identified with dishonesty. It was just down to the court to set the standard. The implied terms there, the court sets the standard of whether or not the cheating has taken place. And that's what happened in this case.
Isn't it a bit more like you've agreed an express term and asking us to interpret it?
Yes, well, that's exactly...
That I think it is what this appears to be.
I suspect that has been the way in which but that arises simply out of the fact that the particular form of words that has been used has been accepted as founding the argument, and so therefore we've argued it on that basis. I think on both sides, to be fair.
Oh, you have on both sides, yeah.
But then the argument was really the construction of this agreement, rather than it being an applied term, because you both take completely different views as to what it means.
Exactly.
And that cannot be an implied term.
But actually, in a sense, what I'm saying is that you've got this agreed implied term, but because you don't agree what it means, we really don't have an agreed implied term. And we therefore ought to be considering, ought we not, the normal rules for implied terms, which so far we haven't. That's really my point, but the Lord Chief Justice puts it rather better than me.
Well, on that point, we would say that the way we have expressed it is exactly what we would expect of the implied term on us. We're not trying to steal a march by setting the implied term too widely.
No, well, you've both agreed it. Nobody's trying to steal a march. I'm not suggesting that. No.
So we are trying to encapsulate what is the quality of the implied term that we would say is obvious in a case like this, that you won't act to subvert the game. Or cheat at it.
In a sense, you could say it comes back to the point you made before the shorter gentleman, I think, that I was doubting, which is this is a game completely brain dead. Yeah. And that may cast some light on the point, but I'm not sure it does. Anyway, thank you. Yeah.
Now, my final point, I realise the time, and I'm not going to go in any detail on this, but my final point was that even if gauche dishonesty is found to be part of Section 42, and it's necessary to consider whether or not Mr. Ivey was dishonest in a gauche sense, because for some reason we've lost on the implied term argument, then we say we win that also as a matter of fact. And really the points I want to make about this are twofold. The first is that my friend has put his whole case in this respect on the absence of a finding by the judge that he has been dishonest, from which he also seems to be saying that the judge has found, on the contrary, that he was honest on the second limb of the gauche test, and therefore he's going to win on that if the gauche test applies. Now, that isn't what the judge said, with respect. If one looks at the judge's judgment at paragraph 49 and 50, which is at A202,
Thank you.
In 49, his lordship says, I've already noted that as far as the civil law is concerned, there's no general agreement as to what one might term the industry standard of cheating or not cheating. It's ultimately for the court to decide, as it must in the case of the standard of honesty to be expected in dealing of businessmen and trustees, whether or not conduct amounts to cheating. The standard is objective. See, for example, Starglade. I accept and follow his statement that ultimately in civil proceedings it's for the court to determine what that standard is and to apply it to the facts of the case. The fact that the claimant is genuinely convinced that he's not a cheat, and even that that opinion commands considerable support from others, see, for example, Dr. Jacobson, is not determinative of the question. It's necessary to analyse what the consequences are of what he did in relation to the game he was playing. And then he sets out why he says it was cheating. Now, what my friend is relying upon is that first sentence of 50. The fact that the claimant is generally convinced that he's not a cheat, and even that that opinion commands considerable support from others, is not determinative. Now, the judge is not, obviously, we say, making a finding about his state of mind. But even if he were, just to complete that point, all he's doing is saying, well, he says that he's being honest, and he says there are other people who would agree with him. Well, fine. But that's not determinative. The whole point of the judge's judgment is that he's not going to make any findings about dishonesty, because that's not part of what he's set out to be the test. So he's eschewing a finding at this point rather than making it. But even if that's wrong and the court believes he is making some kind of finding as to Mr. Ivey's honesty, this is not the second limb of the gauche test. The gauche test is not simply, I'm honest, or I thought I was honest. That's what gauche calls the Robin Hood defense. So you don't get out of dishonesty just by saying, well, I thought I was honest. You have to have a view as to what you think other people, honest and reasonable people, think about what you're doing. Now, Mr. Ivey didn't really go into that. The judge has given some colour to the issues that might arise in those circumstances by talking about the fact that that opinion commands considerable support from others. But he doesn't say anything about whether it is an opinion that's held by normal, ordinary, honest and reasonable people, or whether that is something that Mr. Ivey actually thought about when considering the matter for the purposes of what he did. So there is no finding that he was not gauche dishonest. So the matter is at large. Now, that raises the terrifying prospect of starting again, which I'm sure both sides of the court would not want to do if we can. But my submission is that, in fact, it's not that bad, because the court, on the findings of the judge, can make suitable inferences from primary facts so that the court could now find that he was dishonest.
Do you say that's what Lord Justice Tomlinson really did?
That's principally Lord Justice Tomlinson.
Yep.
So that my friend has offered some criticisms of
Yes.
what Lord Justice Tomlinson said, but we say Lord Justice Tomlinson was absolutely bang on with this, because what he was doing was taking the judge's findings and then drawing inferences about what the consequences of that may be. And he specifically said, well, this is a clear case of deception, of intentional deception. That was the whole point of what he was doing. And it can't be said, in the light of that, we would suggest, that he could have thought that anybody would think differently. Perhaps I could round off just by referring to our own written statement, which is paragraph 45, 1b.
Thank you.
And there we set out what we say was the position on the gauche dishonesty test, which is that the appellant was also aware that what he was doing was dishonest by the standards of ordinary and honest people, because it was common ground that, one, he disguised what he was doing by saying to the staff he was merely superstitious. Two, he sought to cover his tracks by edge sorting randomly once he'd been told the cards would be changed. Three, he didn't come clean about it when he was asked afterwards what he'd done. He only fessed up when he got, in his reply, in fact. Four, he had no reason to believe that the respondent had any knowledge that edge sorting was a ploy available to him. On the contrary, his calculation was that the respondent would not know what he was doing.
It's primarily 1 and 2, isn't it?
It's
Three
primarily 1 and
3 and
2,
4 are sort of retrospective.
For these purposes, yes.
Okay.
But we can say you can spell all of that out of what the judge found, and in particular, Lord Justice Tomlinson's gloss on what the judge found, and his correction of what the judge found about deception, which was an important aspect of the scheme that took place. And so in those circumstances, we invite the court to dismiss the appeal on the implied term, alternatively on the basis that Section 42 either does not involve gauche dishonesty, or if it does. So that has been shown in this case.
Thank you very much indeed, Mr. Pymont. Thank you. Mr. Adkins. Thank you. Mr. Spearman.
Well, quite a lot to get through in 30 minutes to reply, but I'll start, if I may, with the last point. We submit it would be wholly impossible for this court, and quite inappropriate for this court to even attempt to do so, to embark on making a positive finding of dishonesty against Mr. Ivey of any sort, but most especially on the basis of the points that have last been raised, because, of course, disguising what you're doing and covering your tracks are consistent with Mr. Ivey's position that he genuinely had an honest belief that what he was doing was legitimate. And obviously the whole way in which gaining this advantage works is if you're able to do so, and if you flag up that you're trying to do it, you may be stopped, and if you flag up that you have done it, you may be stopped for the future. So it's quite impossible in our submission to take some facet of the evidence of this sort and say, well, therefore, this man was dishonest. That would be, in our submission, completely unfair. The judge heard all the evidence, he saw the witnesses, he considered all the matters. Obviously, his judgment is a summary of some of the matters. These particular matters, I think Lord Justice Tomlinson lit on, I think are hardly mentioned, if at all, in the judge's judgment. And he quite plainly refrained, as Mr. Pymont rightly accepts, from expressing any view on dishonesty. He said in paragraph 45 of the judgment, A201, that he was unconvinced that dishonesty was a necessary element of the civil concept of cheating, as he called it. And so in our submission, it would be wholly wrong for the court to even contemplate doing that. It's quite important, I think, and it's touched on the point that my Lord Thomas raised about the nature of the term and whether it's an implied term or really to be looked at as an express term. There's no disagreement about what the nature of the implication is. The question is, how does one construe it? And I respectfully agree with that. That is the whole heart of this. And what we have been seeking to say is that it is very simple. When the two parties agreed that there would be no cheating, what they meant was there would be no cheating in accordance with the ordinary use of the word cheating. That's what our whole argument is about. The question is, what is that ordinary meaning and ordinary use of the word cheating? And we say that is dishonesty. I know Mr. Pymont says the battle of dictionaries. I say I ought to win that. We've got the better dictionary. But that's what one of the dictionary definitions is. And we say that's what was being agreed.
My point is this really what the issue should be? Should it be the parties agreeing an express term and then arguing about what it means, or should it be deciding precisely what the implied term should be?
Well, I think either way it comes down to the same...
Should come down to
It comes down to the same exercise because your lordship is obviously right. Normally, the whole debate is a term to be implied? But once you've implied...
Well, what is the term to be?
What is the term to be implied? That's absolutely right. But sometimes I think that the court is concerned with, I hope I'm right saying, construing the nature of the implication. There's an implication that things will be done in a reasonable time, and then you have to work out what's reasonable.
Quite.
There's no disagreement that the agreement is reasonable. The question is, what is reasonable?
Yeah, but that's not a question of the meaning of the word reasonable. That's a question of what on the facts is a reasonable time.
Exactly.
Here we're arguing about what is meant by cheating, i.e. we're interpreting the express term.
My lord, if I may say, I totally agree. So what you have to ask is when a casino and a gambler, because this casino didn't have any relevant express terms at all. I think there were some membership rules, but there's no relevant. So this is
Nobody
actually
suggested any of them are relevant, otherwise we'd...
It's an implied term in a contract which is otherwise really doesn't address the issues at all. I think there may be some rules about entry to the club and so forth, but so forth. And obviously they could have had all sorts of express terms, but they didn't have. So it's an implied term in that contract, and they have agreed, and it could be, as Lord Thomas says, they could have written down a bit of paper solemnly, it is agreed that neither side will cheat. And then they embark on the course of activity, and the question is, has the term been broken? And that is the court's function. But our central thesis is, when they agreed that, the word had its ordinary, everyday, natural meaning. And that is why we say dishonesty comes in. It isn't because of, it isn't, we've got into the criminal law and gauche, that's Mr. Pymont's quite right, because his clients chose to raise an additional defence of illegality, and that's right. But the point I make about dishonesty is when the ordinary person talks about agreeing, if you like, not to be dishonest, because I say that's in the expression cheating, they mean dishonesty in my submission a subjective tense. They don't mean some construct which applies in certain areas of civil law where you set a standard of what is objectively commercially acceptable or something, and then you say a departure from that standard and circumstances is going to be called dishonest. The ordinary meaning of the word dishonesty is one which has a very substantial subjective element, and that's the reality of the matter. That's how people look at was this dishonest or not. And if you look at somebody who is seeking to gain an advantage from a casino, knowing that it has a security system, knowing that it may have flaws in the system, and makes a series of open requests of the casino to do a series of things, and the casino agrees to comply, and that gives them an advantage, we would say, in the ordinary use of the word, that is not cheating and that is not dishonesty. That's really, in a sense, the long and the short of it. And I totally agree where we end up. We're talking about a contractual term. I entirely accept that. The reason why we say the criminal law is relevant is not just because of Section 42. It's for the reasons that I gave when I took your lordships and my ladeship to Scott. Scott is a case which is considering the word cheat. Primarily, I accept conspiracy to cheat and defraud. It's considering the word cheat. Yes, it's considering it in a criminal context. That is obviously right. But the point that I made in my opening submissions was, unless the court is looking at the word in some unusual sense in which it will give it a meaning cast in other terms, it will say what it means is X, Y, and Z. If it's using a word, the starting point is to assume that the court is using the word in its ordinary sense. And that is what I say the court was doing in Metropolitan Commissioner and Scott. It was using in its ordinary sense. And right the way through that case, it is perfectly clear that what is contemplated is dishonesty. And I can put it, I think, almost, famous last words, in one sentence, which is when you look at the reference to Mr. Justice James's explanation in Sinclair, which is quoted in Scott. I'll give your lordships the reference, I think, from bundle C. It is C75 in the bundle, page 839 of the report. This is the definition approved by Viscount Dillon in Scott. To cheat and defraud is to act with deliberate dishonesty to the prejudice of another person's proprietary right. The whole heart of it in our submission is those words, deliberate dishonesty, are not adding to the words cheating and defraud, they are explaining them. In other words, cheating and defrauding, and you have either cheating or defrauding. I can give you an explanation of what I think the difference may be, but it doesn't matter. It is acting with deliberate dishonesty. That's what's required. That isn't an added ingredient. The court isn't saying, well, we're looking at cheating, but not any class of cheating. We're looking at dishonest cheating. What it's saying is cheating is acting with deliberate dishonesty. That's what it means. And my submission is that that is not some legal construct or some special definition. That is a reference to the ordinary meaning of the word cheating. There's no artifice about this and no elaboration. It is the ordinary meaning of the word cheating. And that's why I said this case is so important, because it isn't just an explanation of what cheating means for purposes of the criminal law. It is an explanation of what cheating means generally. That's what the court is talking about, not a special meaning of it, an ordinary meaning of it. So that really is at the heart of it, and that's why you see it coming up in the common law offences, you see it coming up in the conspiracy to cheat and defraud offences, and you see it in the one aspect of the common law that has been retained following the enactment of Section 32 of the Theft Act, which is cheating the revenue. Those, of course, are all criminal activities, I accept that, but they're all using, in our submission, cheating in its ordinary form. It's not some special criminal concept of cheating, it's just cheating. And the debate about civil dishonesty tests and criminal dishonesty tests in our submission in large part miss the point, and we've gone over it because the issues have been raised, but the issue is, what do two people who agree not to cheat, and I say that means not to be dishonest, mean by dishonesty? And in that context, they mean the ordinary man in the street's understanding of dishonesty, not what the higher courts have ended up on the basis of accessory liability and constructive trust, having gone through Twin Sectra, Barlow, Clowes, Batcher, and all the rest of it, have come up with as a formulation in the civil law for basically condemning as the wrong side of the line certain types of conduct. I mean, those types of conduct could easily have been called something else. As we all know, in accessory liability, it is split into unconscionable receipt and dishonest assistance, whereas it used to be formerly knowing receipt and knowing assistance. But you could have given a different label to the assistance element, not using the word dishonesty. It's the label that's been given is dishonesty, and it's explained in the cases what's meant by that. But it's not, in my respectful submission, the ordinary meaning of the man in the street meaning, if you like, of dishonesty, which is much more the subjective context, or at least the one which has regard to all the circumstances. In other words, the fact that you've got somebody who is trying to get an edge in a casino, you've got a casino that's trying to defend itself, you've got requests openly made, freely complied with, and so forth. The other areas of law that you've been taking to, in my respectful submission, will help you not one bit on this. It's hopeless going to the Forgery Act or the Bribery Act and saying, oh, well, that doesn't mention, I'm on crime now, it doesn't mention dishonesty, so you can look at this section, section 42, and say there isn't any need for dishonesty in here. The whole point about section 42 is it doesn't contain a definition. It starts off criminalising cheating in a particular context of gambling, and so you have to always ask yourself, what is the nature of the activity or wrongdoing that is being criminalised? And the answer to that is cheating. And where I get the mens rea and the dishonesty element from is from the word itself. That's what's being criminalised. And in my respectful submission, the court has heard no convincing answer, indeed, on one view, no answer at all to this question, given that this legislation was enacted at a time when there was an existing common law offence of cheating the revenue, which is rightly accepted as involving dishonesty, given that there were existing common law offences of conspiracy to cheat and defraud, all of which require dishonesty, as I've demonstrated in Scott, and given that there was one statutory offence of going equipped to cheat, which also required dishonesty, on what possible basis could it be said that Parliament, in extending the criminal sanctions of cheating into the arena of gambling, chose to create a completely different type of offence with a different mens rea, apparently, according to my learned friend, just one of doing something deliberately. That's all. Where does this come from? Why should Parliament do that? Why should it specifically say that if you're to be convicted of cheating the revenue, you've got to be dishonest, the public purse, but if you're to be convicted of cheating at gambling, you only have to do something deliberately, which incidentally does what? It's not just enough to interfere. It must be an interference which has the character of cheating. Just any old interfering with gambling, he may be right that possibly the protester coming in may not be caught by his view, but what about the actual gambler, who, as I said, just gets fed up, exasperated, sick of losing, sick of other people winning, and interferes with the process? I mean, he's right in the middle of it. He's not doing it in order, well, he might be doing it to avoid losses, I suppose, but mostly not. He's put his chips down, and he's just, in my example, just fed up. So this is the crucial question in this appeal, and that's why it's so important in my submission to work out, first of all, what cheating means in this context, and then ask yourself, having done that, whether the facts found by the judge do or do not amount to cheating. It is quite unsatisfactory to do it the other way round and say, this is what happened, A, B, C, and D, and it's cheating, without explaining why. Is it because it's deliberate, as my learned friend would submit on the criminal law? Is it because it's unfair? Is it because it's dishonest? Is it because sitting back and letting all these things happen when the casino's unwitting, but is okay, but making a positive request for something to be done of any sort in some way crosses the line? Is that why? It's important, I would submit, that not only my client, but people in general ought to know what is the dividing line. What is it? And this difference between positive acts and passive acts is at worst a fiction and at best certainly slippery. And I do, I'm afraid, repeat the example I gave, which came, as my learned friend rightly corrected, from Mr. Hopkins, not his expert, Mr. Mills, about the casino that loaded up the shoe with the unshuffled cards unwittingly. Is it really going to make a difference that the gambler can sit back and say, well, this game isn't panning out the way the casino thinks because I'm able to see what's coming because the cards aren't shuffled, and keep asking for more and more hands to be dealt, and if necessary, ask for another shoe to be loaded and so on. And that's all right because he's just taking advantage of the casino's errors. But if he asks for, does he cross a line when he asks for a new shoe to be loaded? Does he say, can we have new cards because I seem to be doing rather well out of new cards, which would be a perfectly accurate observation, but not what the casino would understand to be the true position. It's important to know these things in my submission, and you can't really just say, well, a few things happened, the real position wasn't flagged up to the casino, they wouldn't have done it if they'd known, and therefore it's cheating. And he changed the odds a lot or a little in his favour. My learned friend said more than once, and how the casinos basically play fair, and people are going to go in, they're not going to be stitched up and so forth, and one certainly hopes, obviously, that's right, and what I wouldn't suggest for a moment, I hope that the casino would do something to skew the odds on the cards or a roulette wheel or anything of that sort. But as it's been raised, I'd like to just remind the court of one aspect of the evidence touched on very briefly, which in Lady Justice Arden's judgment, which is the reference that you may or may not have picked up at the end of paragraph 66. It's page A174. This picks up a point that I was being asked by my Lord Newburger in my opening submissions, in paragraph 66.
Thank you.
This is my A174. I won't read all of it. It's my submission. They could have done things to prevent it. They didn't need to do it. I'll pick it up from the middle of 66. Crockfords deliberately chose to accommodate the requests made by Mr. Ivey and Miss Sun. Mr. Ivey was entitled to exploit their defects in procedure. These are my submissions, obviously not her rulings. The casino has a commercial motive to keep the gambler happy, and therefore offers him as much as possible. Mr. Spearman makes the point that Crockfords offer free drinks and provide trend screens. Trend screens show the results of previous hands of baccarat, which suggest a pattern exists, but which they accept it does not. This arose out of a particular piece of questioning, because Mr. Ivey was gambling in a private room, so it was just him and the casino and various casino staff. And a screen appears which gives you the outcome of previous hands. How many times has banker won? How many times has the player won? And I cross-examined one of the casino's witnesses to say, well, the purpose of that is to encourage people to think that there's a pattern in the play and to bet accordingly. And the witness denied that that was so, said it was just information. But he gave the answer to my question, saying the trend screens are just there for information. That was his wording, not mine. And we say that that is, if you're going to get into fairness, I just asked the question rhetorically, where does the boundary lie with casinos allowing gamblers to gamble, encouraging them to remain and gamble, and so forth? If you're going to put fairness in, where's the boundary? And I repeat what I said in my opening, that if the implied term was meant to be one that neither side would behave unfairly, that is not really the nature of the term that's been pleaded, and it would give rise to, in our submission, very different considerations. What's been pleaded is an implied term, and Lord Thomas may be right, it could have been put as an express term, it wasn't because we could have shaken hands on it, that there would be no cheating. And there hasn't been any cheating, because cheating, in our submission, always comes back to dishonesty. And it certainly, in our submission, comes back to dishonesty in section 42. And to say that something short of dishonesty can lead to the criminal sanctions that 42 would be wrong. So I'll just end in this way. In fact, Lady Justice Arden and Lady Justice Sharp were not wrong in the approach they produced, because it comes to the same thing. They looked at section 42 as being a reflection of the meaning of the word cheating in the gaming environment. They took different views of it, that's true. Lady Justice Arden basically sided with my learned friend and said, well, interference is enough. And Lady Justice Sharp sided with me and said it's got to be dishonesty. But it wasn't because they were, so to speak, saying shoehorning section 42 into the contract. It just comes down to the same thing. Essentially, what happened is these people agreed not to cheat. Section 42 criminalises cheating, the self-same activity. The question is, what is that activity? And in our submission, it's an activity that involves dishonesty, and dishonesty is not made out, and was never made out, on any view of the facts of this case. And for those reasons, we submit the appeal ought to be allowed. Could I just have one moment?
Of course.
I'm just reminded by my learned junior, for which I'm very grateful, that of course the implied term is said to have two limbs, not to cheat or otherwise, I think, act in such a way to subvert the central premise of the game. I made these submissions in opening. We say that the judge rightly treated that as the same as the first ground, no game was played at all. It's the same point. The essential premise was destroyed. He rejected that, and that's never been appealed. So we say it's just using the same expression twice, really. That's all dealt with under the first ground. But, my lord, that's what my submission is.
Yes, indeed.
Thank you very much, Mr. Spearman.
Well, thank you.
Got it all in well in time. Thank you.
Well, 4 minutes to spare isn't bad. Thank you very much, my lord.
Well, thank you both for your submissions, Mr. Spearman, Mr. Pymont, and thank you also to all those who were involved in preparing the written cases we found very helpful. We will consider this matter and let you know in due course. Thank you very much indeed. Court's now adjourned.